ଭଗବାନ ଟିକେ ବସନ୍ତୁ ଦେଖ hello
Hello, sir.
Suchintita, probably on the other day you had faced the interview
Yes, sir. Yes.
previously. From where you are staying, residing?
Sir, I am from Bhubaneswar.
Bhubaneswar. What is your academic qualification?
Sir, I am a LLM in Constitution and Administrative Law.
Constitution, administrative law. Yes, other day what? Constitutional. What is your view regarding uniform civil code?
Sir, I have a mixed view regarding Uniform Civil Code uh, because Uniform Civil Code unifies the personal laws of all the religions for that matter. But recently it was implemented in Goa, and a repercussion happened due to which the principles of Christian laws prevailed more. So in India, if we see, we have a majority of Hindus. So if Hindu laws provisions will prevail, I think so that will be opposed by a lot of people. So for that reason, if uniform civil code is to be implemented, then proper way and a balanced approach from all the personal laws should be taken, so that uniform civil code can be done in its highest form or highest satisfactory form.
Why you think that the laws applicable to Hindu will be applicable to other religion? When there will be uniform civil code, at least this is a civil code that will be applicable taking all the laws, not only of Hindus, but also of the Mohammedans, Christians, every laws are to be taken into consideration. Why the uniform civil code is to be drafted? Is it not?
Yes, sir. Sir, actually, theoretically, that is the aspect. But recently in Goa, it was implemented in the recent past. So practically, the thing happened that it was um, majorly Christian laws prevailed more. Although every religion's laws were there, but Christianity laws was more because Goa is predominantly by the Christians. So I think so. If that will not be an issue, then uniform civil code, if it is taken all religion's laws in a balanced way, I think so that will be a best form of
Because there
implementation.
will be issue, as because there will be issue, why there will be no civil code, uniform civil code? When there was also a lot of issues when Hindu code was enacted and Hindu laws were enacted. In Hindu law, there was only monogamy. Then that polygamy was there, and this that divorce was not there. They even not no property right was given to the women. If a drastical change was made for Hindu laws, a majority of population, for minority population, why there is an obstacle for changing, bringing this uniform civil code?
So before implementing any law, prevention is better than cure. So if all the standards shall be taken, I think so that will be implemented in a better way. Otherwise, implementing now, it is not a problem.
And what is the benefit by implementing this uniform civil code in India?
In India, as we have other civil laws, all criminal laws, every person is bound by the similar civil laws and criminal laws. So, personal law being a different law, so I think it is creating a inequality between the people who follow different personal laws. So, if uniform civil code will be there, I think so there will be uniformity in the judicial process and the justice giving process. So, uniform
What is
civil code.
Adi alterum pattern theory?
Adi altrum partum theory is a theory of natural principle of is one of the principle of natural justice, which talks about no party shall be left unheard. If a party shall be left unheard, then that will uh, create prejudice to the other party. So everyone should be heard in the court of law.
A judgment was given. Simply a bail application for bail was filed. There the magistrate mentioned in the order, hard, the bail application is rejected. Whether this violated the principle of natural justice?
Uh, Principle of natural justice is for the ordinary suits. If Bail is
The magistrate
rejected
heard both the
without
parties. The
the,
magistrate heard the prosecution as well as the accused advocate for the accused, but passed an order, heard the bail petition is rejected.
no, sir. If both the parties are heard, then that is not a violation of principle of natural justice.
If a major girl can claim maintenance from her father as per section 125 of the CRPC on the grounds that she is unemployed, she has no income to maintain her.
Yes, sir. There is a case law, that is Vijay Manohar Sharma versus Kashirao Rajaram, where a major married daughter or major daughter can also claim maintenance from her father if she is unable or if she is incapable in any of the ways.
On section 125 CRPC.
Yes, sir.
Can a stepfather claim maintenance on section 125 of the CRPC?
Stepfather. Uh,
Stepfather.
Stepfather. Sir, I will look into it.
What is promissory estoppel?
Promissory estoppel is an estoppel which is to bar if someone has promised something to do something in the past legally, then that person cannot deny or retract from that in the future.
Then what is estoppel by estoppel which is applicable against the tenant?
Estoppel which is applicable against the tenant, it is given in 116 of Indian Evidence Act, which talks if someone has is under lease and someone has taken a tenancy under a person, then he cannot deny the ownership of the owner or the lessor who has given him tenancy.
Even
Because
after
once,
termination of tenancy, can you deny?
no, once he has accepted the tenancy, then he cannot deny even after the termination of the tenancy.
There is a dispute prove the handwriting or signature of a person. A document was produced and there is a dispute arose whether that is the handwriting or signature of a particular person. What the court will do?
Court has two. If we see, court has various ways to check. First is under Section 47 of Indian Evidence Act, whether the handwriting is of that particular person or not. Things can be checked by asking the person who has seen him writing, or has received any documents from him, or in ordinary course of business has received any handwriting note from him. And secondly, the court can compare handwriting under Section 73, signature and comparing. And plus, if we add on or drag the provision of Section 45, that might be also right, because Section 45 also talks about expert evidences on handwriting as well. So their handwriting experts can tell whether that particular handwriting is of a particular person or not.
Suppose you are trying a rape case. The victim gave evidence that she was ravished, and the medical examination showed that there was no sign of rape. And can you record a conviction basing on the sole testimony of the victim?
Sole testimony of the victim saying that there was no rape.
No, victim says there was a rape, but the doctor says did not find any sign of rape after medical examination.
Okay. So then, any other registered medical practitioner will be asked to uh, medically check that person. Then,
Why
if
medical check the person? Already rape was committed, there was allegation. After a long period, you are conducting trial.
Here,
The
here actually, there are two kinds of evidences. One is medical, and one is uh, uh, this medical witness.
my question is, can the session judge or usually rape cases are tried by assistant session or session judge? Can the assistant session judge or the session judge record a conviction ignoring the medical evidence, basing on the testimony of the victim girl?
Yes, sir, because always the testimony of a victim girl is in a higher evidentiary value from the expert evidence. So he can.
Suppose there is a murder and the witnesses cited are the wife and brother of the deceased person. They gave evidence to prove the murder. They were the eyewitnesses. Can the evidence of those two persons be relied and a conviction of murder be recorded against the accused?
So the two persons told that the murder had is committed.
Yes, they are the relatives of the deceased.
Uh, yes, sir, because as the person is not there, so the informants, if they're at the, even if they are the relatives, the conviction can be done.
What is the effect of delay in lodging affair?
If there is a delay in lodging affair, a sufficient cause will be asked for why the delay has been caused. If there is a sufficient cause shown properly, then FIR can be lodged. Otherwise, if there is inordinate delay, then FIR cannot be lodged.
Cannot be lodged. Is there any time limit for lodging affair?
There is a gap of reasonable time. If they are going for an unreasonable gap, then there is a question of concoction of that FIR. So
Suppose in a rape case, after 1 month a fire was lodged, whether that will be entertained or not.
yes, sir, because this is a reasonable gap, uh, not after 20 years or 30 years. So I hope so. This is reasonability or a prudency can be checked by the court itself or by the police station who is lodging FIR.
Can the police reinvestigate a case without the order of the magistrate?
Yes, sir. Under um, 173.8 clause, section 173.8 of CRPC, further investigation, if it is required, then the police can do before submitting the final charge sheet.
Before charge sheet, even charge sheet has been filed. Even after filing of charge sheet, police wanted to investigate, make further investigation in the case. Can you do so?
After filing the charge sheet,
Yes.
uh, if the charge sheet is filed, then, sir, I'm unaware of that. I will look into it.
What is a lease?
Sir, lease is a transfer of a right of enjoyment which is given to a person, and there are various types of leases. Then there is a period of lease, and if one time payment is given, that is premium, and if monthly payment is given, that is rent. So it is basically a transfer of a right of enjoyment.
What is license?
License is a transfer of a right to perform something on a particular land or a yeah. Because the difference between lease and license is lease is just a right of enjoyment, whereas license is the right of performing some act uh, by the person, by the licensee.
What is divorce by mutual consent?
Divorce by mutual consent is a divorce where a joint petition is given by both the parties, husband and wife, that they cannot live together. So they file a joint petition in order to dissolve their marriage, and 6 to 18 months of time gap is given. And earlier there was a cooling period also, but after Amardeep Singh versus Harveen Kaur, the cooling period is no more necessary. If the husband wife find that it's very difficult to live together, so they can file for dissolution of
If
for
the family judge is permitted to reject a petition filed by the husband and wife for divorce by mutual consent.
to reject the petition.
Right.
Uh, yes, because if under Article 14, any alternative relief is there, or if under Article 15
Why
they are doing
article?
some.
Because Article
Sorry,
14,
no, sorry,
15
not
may be
sorry,
applicable.
section. That's section. I'm so sorry. I just it was a slip of tongue. Under section 14, if the alternative relief is there, and if under section 15 there is any other ground available for divorce, then I think so. Magistrate can, family judge can reject. Otherwise, if divorce by mutual consent is given in a full form, they should not reject.
In a warrant procedure, charge is to be framed. The magistrate omitted to frame a charge. The trial commenced, ended in conviction. Thereafter, in appeal, the convict pleaded that there was no charge, so I be acquitted. So I may be acquitted. Whether the appellate court can acquit.
Yes, sir, because it's uh, any uh, regarding the judgment of the lower court, the higher court can reject the decision in appeal.
What is the difference between criminal appeal and criminal revision?
uh, Criminal appeal is basically the aggrieved party, if he or she is very dissatisfied with the decision, then they can go for appeal. But in revision, if if a question of law is to be questioned, or if any call for records is to be done by the higher court, then the high court or sessions court, then they can call for revision. So here, appeal the party is asking for, but in criminal revision, the court is asking for calling of records for revision.
But if the party cannot file a petition for revision.
In the higher court, yes. Here, the so moto here so moto can also be done in criminal revision, but appeal so moto cannot be done.
What is the difference between standard of proof in beyond reasonable doubt and preponderance of probability?
Okay, yes, sir. The beyond reasonable doubt concept is basically criminal. In order to learn the criminal law, where accused can be made guilty beyond any reasonable doubt or suspicion which arises if the accused is free from all the questions, or the conduct of the accused is free from all the doubt, then only he will be made guilty. Otherwise, if there is a single question, then also the accused cannot be let guilty, because it is based on a maxim, nine guilty may be free, but one innocent shall not be accused. Then the preponderance of probability is a case is a same analogical provision in civil law, where beyond all probabilities, if the defendant side is getting the is proved being doing wrong, then only that defendant side will be proved wrong. Otherwise, no. Otherwise, same provision will be applicable.
If the accused is required to prove his plea beyond reasonable doubt or as preponderance of probabilities in a criminal case,
Accused, accused beyond reasonable doubts.
accused wants to plead his plea. Other beyond reason, prosecution will prove its case beyond
Yes,
all
yes,
reasonable
sir.
doubt.
Yes, sir. Yes, sir. Yes, sir. Sorry.
Then the
Yes.
accused wants to plead, his plea is to be proved as preponderance of probabilities or beyond reasonable doubt.
The preponderance of probabilities.
Have you seen any case law to that effect?
No, sir. I'm unaware.
Why such a relaxation is given to the accused?
So, because the same maxim, I'll again repeat, if uh, nine guilty may be free, but one innocent shall not be accused or shall not be
Nine
punished.
guilty and 10 guilty. Like, that is, let nine guilty may free, but one innocent should not suffer.
Yes, sir.
That
Yes.
is the okay.
Yes. Yes.
Who is an accomplice?
Sir, accomplice is a partner in crime, and who is aiding the person in commission of a crime.
Anyhow, let us. I will give my feedback after the your second round of interview is done. Thank you.
Thank you, sir.
Tell me, what are the stages of crime?
There are four stages of crime: intention, preparation, attempt, and accomplishment.
And what are the elements of crime?
There are four elements. One is human being, injury, mens rea, and actus reus.
What are the remedies available to the person under the tort law?
Uh, the remedies is damages, compensation, or injunction, or distress damages, or self-help, or habeas corpus can also be done in case of trespass, etc.
Okay, and what are the general offenses available under the law of torts?
There are around 10 to 11 general defenses. Example: voluntary non-fit injuria, act of God, then necessity, statutory authority, private defense, plaintiff the wrongdoer, then etc. There are various inevitable accident.
What do you mean by free consent under the law of contracts?
Free consent is defined in Section 14 of Indian Contract Act, which talks the consent shall be free from all kinds of other wrongs like coercion, misrepresentation, uh, undue influence, fraud, and mistake.
Under which provision of the Indian Penal Code the consent finds its place?
Under Section 87 of Indian Penal Code, the consent and or the concept of voluntary non-fit injuria is there, finds its place.
I'm asking about the consent under the Indian Penal Code. Under which provision it finds its place?
87, Section 87.
What are the distinctions between complaint and FIR?
FIR is lodged in a police station and complaint or in front of an officer in charge of a police station, and complaint is lodged in front of a magistrate. And FIR can be lodged in cognizable offences only, whereas complaint can be lodged. Complaint can be filed in both offences.
What are the differences between inquiry and trial?
Uh, Inquiry is the second stage of the criminal proceeding, where from the filing of charge sheet to framing of charge. Inquiry is delving from filing of charge sheet to framing of charge, and trial begins after framing of charge to the final conviction or acquittal.
And what are the differences between investigation and inquiry?
Investigation is a non-judicial proceeding, whereas inquiry is a judicial proceeding. Investigation's step starts from lodging of an FIR to filing of charge sheet. This is the period of investigation. Then, after filing of charge sheet, the judicial proceeding starts, where the cognizance is taken by the magistrate, and it's from framing of charge to from filing of charge sheet to framing of charge is inquiry.
What are the differences between summons case and warrants case?
Summons case at those cases where the punishment is up to 2 years, and warrant case as per 2x of CRPC. Summons case is as per 2W, and as per 2x of CRPC, warrant cases is beyond 2 years. Death penalty, life imprisonment, everything is covered there.
Under which article of the Constitution of India the establishment of High Court has been defined?
214 of Article 214 of Indian Constitution talks about the establishment of the High Court.
And the establishment of Supreme Court?
124.
Can you say that whether an accused can file an affidavit at the stage of defense evidence?
Accused can file an affidavit at the stage of defense evidence.
Yes. Whether an accused can file his evidence in shape of affidavit at the stage of his defense evidence.
Yes.
What is transit bail?
Transit bail or transit remand, when a person is in transit remand, there if the bail is granted, if someone is traveling, if the person getting arrested is traveling from one place to the original jurisdiction, then in between that, if that person is claiming bail, then that is transit bail.
Which court can Grant the transit bail.
The court where that person is staying before reaching the original jurisdiction court.
How the period mentioned under section 167 of CRPC, how it will be calculated, whether the date on which the accused has been remanded to custody, whether that date has to be included or not.
Uh, the date from the date when that person is into the custody, from that very date,
That will be included.
perhaps.
What is arrest?
Uh, Arrest is not defined in CRPC. Rather, it is uh, restraining the liberty of a person if that person has done any kind of offense as per IPC or any other provision of law.
If a person has committed offenses in the same year, okay,
Repeat, sir.
then all these offenses can be clubbed together for trial.
In the same year, yes, yes. Under section 219 of CRPC 219, if three offenses are committed in 1 year, then there can be a joinder of charges.
Whether the High Court can conduct trial, a criminal trial,
Yes, High Court can
under which
conduct
provision?
under section 474 of CRPC.
474. What are the differences between first appeal and second appeal under the
Uh,
CPC?
CPC, yeah. First appeal is given in section 96 of CPC, where from any decree which is given, then from any ex parte decree or from consent, there can be no appeal, or any kind of small causes cases, their appeal can be done. Then order 41 also deals with that. But second appeal is always on a question of substantial issue. When there is a question of substantial matter, then only second appeal can be done, and first appeal can be done to any higher court and any appellate court, but second appeal is always done to the high court under section 100 and order 42 of CPC.
Whether a criminal court can review its own order?
The concept of review is not there in criminal law. Concept of review is only in civil law.
What does the section 362 of the CRPC says?
362. No idea. I will look into it.
Okay. What are the questions to be determined by the executing court under the Code of Civil Procedure?
Under section 47, the questions regarding execution, discharge, and satisfaction can be done by the executing court.
Okay. The conversation between a husband and a wife, that is a privileged communication. Okay. Suppose you take a case there. A being the husband has recorded the conversation of his wife. Okay. The conversation, what happened in between A and B, both the husband and wife, he has recorded. And later on, during the course of a divorce proceeding or any matrimonial proceeding, he simply produced the same without the knowledge, and the same which was recorded without the knowledge of his wife B. Okay. Whether that conversation can be considered as a privileged communication or not.
If this conversation would have been recorded by the any of the party or with their consent, then only as the dispute is between the husband and wife, that could have been used. But if as the consent is not taken, I think so it cannot be used. If any of the party will agree to it, then that can be used, because the dispute is between husband and wife only. So no more privileged communication is there.
Whether complaint petition can be amended,
Yes.
or which provision?
uh, if there is a dismissal of complaint under section 203, then there is a provision of amending the complaint. And in the case of Sukumaran versus state of Karnataka, I think so, their concept of how and within which limit complaint can be amended was given.
What are the provisions governing the substitution of complainant in a criminal trial?
Substitution of a complainant. Uh, It's in 216 of CRPC where sorry. I will look into it. I'm just cannot recall that.
Whether a victim can prefer an appeal before the appellate court?
Yes.
Under which provision of CRPC?
Section 372. It was amended in the year 2009.
Under which provision of the CRPC the victim has been defined?
Victim is defined in section 2WA of CRPC.
Whether the charge includes the trial or not?
Charge includes the trial as in the stages.
Yes.
No, the trial begins after the framing of charge.
What are the theories of divorce?
There are three basic theories. One is irretrievable breakdown theory, one is consent theory, and one is fault theory.
What are the conditions of Hindu marriage?
There are five conditions. First is under Section 5 of Hindu Marriage Act. First is there must not be a spouse living at the time of marriage. Second, both the parties shall be capable, and they should not be incapable mentally, or there should not be recurrent attacks of insanity. Then third is the age of both the parties shall be lawful, 18 for the girl and 21 for a boy. And fourth is that they should not be under prohibited degree of relationship. And final one is they should not be under subpenda relationships.
What is cognizance?
Cognizance is not defined, but it can be told as the application of judicial mind on a particular matter.
Okay, very good. You answered very well. My learned sir will give you the feedback. Thereafter, I will come back to you.
Thank you.
Hello, uh, Suchintita,
Yes, sir.
because you are postgraduate law in which subject?
Constitutional law.
Constitution. Uniform Civil Code is a direction, is a DPSP, that if provision is there, so it is the responsibility of the state to implement it. That will be your question, answer. That will be your answer. Since a direction is given in directive principle state policy, state has the duty to implement it. Once, never owe your problem. Uniform Civil Code will bring unity and integrity of our country. This answer. Never room various things. The opinion may be in your mind. I think in my view, I think perhaps you may use perhaps the UCC will bring this integrity and unity in our country. Yes. Audio alternative pattern theory. You are well. Bail application rejected. No, here the natural justice is violated because order should be assigned with regimes. Without regime, there should not be any order. Natural justice demand that a person must not be a judge, should not be a judge in his own case, audio alternatum, and whatever order will be passed, judgment or decision will be given with some regimes. Simply hard rejected, here natural justice is violated. A major girl is not entitled for maintenance only when she is handicapped, mentally handicapped, or then she can get. You go through section 124, that's a misconception. Sometimes a major girl, but she can claim maintenance under the Hindu Adoption and Maintenance Act. Such a provision is there. Stepfather is entitled for maintenance. Promissory estoppel, if on the promise of somebody, a future act is to be done, then that is, and somebody has changed his position, then promissory estoppel will be applicable. For an example, suppose the state government issued a circular to give tax benefit to a person who will establish an industry. A person incurred loss, already established industry. then he cannot do it. Future 5 years, that is provisory estoppel. Estoppel tenant, after termination of tenancy, this estoppel is no longer applicable. That you see, while in undergoing that tenancy, during subsidies of tenancy, this estoppel principle will be applicable. After tenancy, he can deny. Principle of estoppel will not be applicable. To prove the handwriting, either that is a person who is acquainted with the handwriting of the person or signature, he will be examined, or that may be sent to handwriting expert with the admitted handwriting and signature for examination. As per section 73 of the Evidence Act, victim testimony is sufficient to record a conviction, even by ignoring the medical evidence. In a rape case, you go through the case law, you find the case law. Many case laws are there. Evidence of relative, yes, that is believable, conviction can be recorded. Just because they are relative, since they are eyewitnesses, their testimony should not be discarded. Delay in lodging affair, that facts and circumstances of each case is to be considered separate. Particularly in rape case, there will be more relaxation, because in our society in India, normally when a rape is committed, people feel shy to go to the police station for their dignity, etc. So there is every possibility of delay. So that should not be wrong. If that is reinvestigation can be done even after filing of charge sheet, but though 173(8) doesn't require the permission of the court, but the judicial propriety requires that with permission that should be reinvestigated with permission after charge sheet. Lease is a transfer right of enjoyment of certain property one side also for certain period in payment of rent or periodical payment or in payment of price, that is called payment. License means you committed a permission to enter somebody's land without which the entry is illegal. That is license. When meter reader comes to your house to take meter reading, he comes here as a licensee. Best example is when you go to to view a cinema. By purchasing a cinema ticket, you enter there as a licensee. Licensee is cinema ticket, lease is house rent. People keep. Divorce by mutual consent, you are also, if they are living separately for 1 year and more, and they are unable to live together, they have mutually agreed to dissolve their marriage by decree of divorce. The three conditions must be mentioned in this divorce petition. Reject, yes, when they find is a collusive petition. Collusive, it is not collusive. That can be rejected. Sometimes for getting any relief, say for in a corruption case, husband and wife they get divorce to suppress wealth, or collusive nature, or to avoid stealing laws, some laws, they go for mutual divorce. That can be rejected. Collusive divorce. Want of framing of charge, that is 464. Any error in charge will not vitiate the trial unless that will cause prejudice to the accused. Prejudice. Criminal appeal and criminal revision. Criminal appeal is a statutory right given to a person that because in every civilized society, at least some forum of appeal is prescribed. So here criminal appeal is a statutory right given to the convict to prefer appeal. But criminal revision, either by petition of the party, call for the record of the inferior criminal court in order to satisfy regarding the correctness, legality, or propriety of any order finding sentence. That you see. Beyond here I put a quote in the accused should prove his plea as preponderance of probabilities, not beyond the reason of doubt. But the prosecution will prove the prosecution case beyond all reasonable doubt. Probably you are clear, you have concept clear. Again, be cool and answer it. Just study the mind of the interviewer, how he is putting a question, what is his, that is, maybe there are different type of interviewer. So you should try your best to please the interviewer. Thank you. I wish you success.
Thank you, sir.
Hello, Suchintita, you have answered very well. But so far as there are some questions relating to computation of period under section 167 of CRPC and the privileged communication are concerned, just have a glance to the 167 of CRPC with the recent case laws, as well as so far as the privileged communications are also in between the husband and wife are concerned. Now, so far as the other aspects are concerned, you have answered very well. So, just have a glance to the recent judgments as well as the recent judicial pronouncements and the precedents. And the conceptual, you have a very good conceptual understanding. So far as I asked you regarding the complaint, the FIR, inquiry, trial, investigation, you have answered very well manner. So far as the other aspect, another thing I have left, that is the affidavit filed by the accused. Okay, so you look into all these matters, and so far as you have a specialization on the Constitution of India, I forgot to ask you some questions with regard to the constitutional heads regarding the power, executive power, and the power of the president, honorable governor, and so far as the other aspects are concerned regarding the constitutional validity, which some of the questions have been asked by sir. So you have a better look into those aspects regarding your specialization and the statutory enactments. So all the best for the examination.
Thank you, sir.
Okay.